Welcome to All Things Social Security. Enjoy your video. Hey guys, just had a little chat through the portal with a probable new client, and she had a really good question, and I wanted to share it to everyone else. I already kind of shared her my take on it, but I think it could be helpful for others. And this applies to the people that read the fine print. And so I'm really impressed with this fine lady because kind of a woman after my own heart. I tend to be a fine print reader myself. Boy, I can totally tear you open in knots, but when we don't read fine print, sometimes we live to regret it, right? So she pointed out that on the 1693, which is the fee agreement designed by the SSA, so it's like their official version, although representatives are free to use their own version. They just have to make sure it complies with the fee agreement rules. Okay, so, and the 1693 came out a few years ago, and I jumped on it because I, like everyone else, had my own fee agreement, proprietary fee agreement, if you will, for the last 20 years or whatever it was then. Maybe it was 19 years or something, 18 years. And once in a very blue moon, whoever was reviewing the contingent fee agreement to see if it meets the law, some dim light would reject it, even though it's been the same one used in my practice forever. So it was just someone who couldn't read English very well, or, whatever. Maybe they had a bad day. And then the result is you have to go do a fee petition, which, by the way, there's no $9,200 cap on the fee petition, but it's a pain for a bunch of reasons. I have videos on that. So when they came out with this, I was like, this is great. Now they can never reject my fee. It said the same thing. The fee is always going to charge to be the same. They would just get confused on language, I guess. So I jumped on this and it's been happy-go-lucky ever since. But my person here pointed out a paragraph that I hadn't even thought about or whatever, just because I know the general rules and the ones we follow. So here it is. In the 1696 on, I guess it's the first page, probably the bottom third of the page, there's a paragraph that says, I understand that my representative may still request a fee even if my case does not result in past due benefits or the determination or decision is not favorable. Now, the first part is clear. Yeah, if there's no past due benefits, then we jump on if we are so inclined to do a fee petition. I have a video, I suppose I can attach it here. It didn't come out that long ago, and to it, I had attached information about fee petitions and in particular, the way we generally choose not to do them. But that's when for us, when there's a win, but no back benefits. And therefore, to get a fee approved by the SSA, they can't use the contingent fee because it only relies on if there is back benefits on the win, not if there's no back benefits on the win. Fee petition outlet for all the attorneys that there's no back benefits, but they won the case and the person's getting prospective benefits. Fee petition is available. We just don't tend to do them 99% of the time. And the times that they're even something that you would consider is maybe 2% of the time, because almost invariably the contingent fee agreement results in some sort of back benefit, even if it's only $1,000 back benefit and the attorney gets $250. We kind of roll with it. That's just how we do it. I have reasons for that. I explain it in the video elsewhere, but I understand I'm a weird bird in that way. But the other part of the sentence was, or the decision or determination is not favorable. So I never even paid attention to that because that is something that has never happened in my firm. Not that there haven't been unfavorable determinations or decisions, but I've never considered filing a fee petition. I don't think lawyers generally do so. I've never heard of one that ever filed a fee petition on a case that they lost. It's just, I don't even know how it would happen. So I was trying to think of examples of, wow, when would the SSA, why would they even have that in there? And the only reason I can think of, let's say the claimant is a real bad actor and the claimant has put forth a fraudulent case and totally duped the lawyer, has perhaps a team of fraudulent doctors. Everything has been fraudulent, lied, cheated, and stole everything. And the lawyer's doing, years of work with best of intentions and good faith. And this person has been intentionally defrauding. And then it gets discovered by the SSA. I would assume they would be prosecuted. I would certainly hope so. And the lawyer's like, I just did 1,000,000 hours of work over 4 years, and there's going to be no fee, obviously, because they can't win because they were fraudulent. And I've been all this time in equity. I should be paid by them. They need to pay for this. It's a cost that they put on other people. It's like stealing. I think I'm just guessing here. I've never heard anything about this. I've never seen it. It's never, my colleagues and I have never even discussed it because I don't think anybody even notices that because no one would ever ask for a fee on a case they lost. It's contingent. That's the way we look at it. So I'm thinking that is probably why they have it in there. So they can. SSA can be like, oh, listen, you MFer, you just tried to rip off the SSA. We finally caught you. And now you're going to let this hardworking representative, it could be attorney, it could be non-attorney rep, be hung out to dry, wasted all their time, spent money on their staff, et cetera, maybe even paid for medical records, whatever. And maybe that's their tiny but rarely, I can't even imagine. I've never even heard of any of the fraud cases I report on, any mention of, oh, and they decided that they're going to owe the attorney too, or the non-attorney rep. So I don't think, I've never heard of it happening in 20 something years, but it was just a great point that she pulled out of here because she was reading the fine print. And I thought it would be good to share with you that it is in there. But that is my take on when and how it is definitely not used. And when might it be, which should never then be your concern. So, and always remember that any fee, whether it's through the contingent fee agreement or the fallback of the fee petition, it always has to be approved by the SSA. An attorney or a non-attorney rep can never, ever, ever charge you for their legal work. If they do, they're violating rules big time. And for lawyers, it's probably something that their bar would take issue with. I know there have been lawyers who didn't understand SSD law and were just kind of like grabbing cases where they could and never really studied up and were sending bills to clients as if they were like divorce clients getting billed by the hour. And pathetic. I can't believe you would take on an area of law, particularly an administrative area of law like this, and not study the administrative law that surrounds it. But they have done that. I don't think it's common, but I could think of one firm off the top of my head that did it. So anyway, I just wanted to share that to you because I thought it was interesting. And I just had responded to her through our portal to be like, oh my gosh, okay, let me just tell you my thoughts on this. And then I also said, and by the way, we won't do that. And you have this in writing from me right now. If your case doesn't win, we're not filing a fee petition. And in fact, for a case like hers, I wouldn't even be filing it if we won and there were no back benefits, but she's getting perspectives because I don't perceive her as a super rich person with high income coming in the door, So anyway, that would defeat my whole purpose, as I allude to in the video. And I'm just going to attach it. It might even be, yeah, I'm going to attach it. There is the one I found was a segment with a little Q&A in the front. So you're going to see all that fuzzed out area. But then attached to it is a whole explanation on fee agreement versus fee petition, focusing on the fee petition aspect so you have a better understanding. So if it's of interest to you, feel free to continue listening, and I'll talk to you guys later. Bye. Good morning. Wanted to share some of the details about a fee petition. This is the alternative format for a representative who's been officially appointed and represented a person to completion and to prevailing. One of the two ways of asking the SSA to order a fee, prove a fee is actually the proper word. So, the first way of getting paid by a rep is through that contingent fee agreement you probably signed. That's the one most people are familiar with, 25% of back benefits capped at whatever the current legal cap is. As you may know, in 2024, at least up until November, or end of November, at least, it is $7,200 as a cap. So even if you had $100,000 in back benefits, the representative would not get $25,000, they'd get $7,200. That amount is changing to, as I understand it, $9,200 by the end of November 2024. And if that sounds troublesome, it really shouldn't be, only because they went for far more than a decade without getting an increase in the cap, despite everybody else getting COLAs. So I think they're trying to change that and make everything always have a COLA. There are other things that don't have COLAs that should. This is one of them. So in the event that there is no back benefits, but you prevailed, and that can happen if the onset date that the SSA agrees you became disabled at was not the one that you asserted, and it was much later such that you might still be in at the time that they award you in that 5-month waiting period that applies to Social Security disability claims. That does not apply to SSI claims. So if there is no back benefits from which to derive a 25%, can't get 25% from zero, then people will file for under a fee agreement, the alternative. And that's where they itemize all the work done, times it by their billable hour, and that amount and the whole itemization is submitted to both the claimant to see and the SSA, who will decide what the fee is going to be. They don't necessarily go with what all the work was. And I wanted to go into what would they be considering, so you kind of know what they're looking at when they decide what to award. So, or approve. Okay, so they tell us, and it's literally in the SSA-1693 petition paperwork. So if you read the fine print, here's what it says. Evaluation of a petition for a fee. SSA determines a reasonable fee for the services provided on a claim, considering the purpose of the Social Security program and or Supplemental Security Income Program. So it can apply to either of those programs. Number one, the extent and type of service the representative performed. Number two, the complexity of the case. Number three, the level of skill and competence required of the representative in giving the services. Number four, the amount of time the representative spent on the case. Number five, results the representative achieved. Number six, the levels of review to which the representative took the claim and at which level he or she became the representative. That was six. And seven, the amount of fee requested for services provided, including any amount authorized or requested before, excluding any amount of expenses incurred. They go on to say that the SSA also considers the amount of benefits payable, if any, but authorizes the fee amount based on consideration of all the factors listed above. The amount of benefits payable in a claim is determined by specific rules unrelated to the representative's efforts. In addition, the amount of past due benefits may depend on the length of time that has elapsed since the claimant's effective date of entitlement. Okay, so that last part there, they consider the amount of benefits payable. This is important because I do believe, and very rarely do we have to do a fee petition. It's like, I'm pulling this out of my yang, but I think it's like 2% or something. It's just very rare. Nobody likes it. The representatives certainly don't like it. Even though the irony is you're not limited to that 7,200 we were talking about before, but it's a load of work to prepare. It's just a pain. And the SSA does not make it their priority to figure out what the fee is going to be. You could be sitting on it for 18 months and waiting. So, and then what's happening? Did they withhold it? Did they withhold some amount from the withheld back, if there were back benefits or not? I should emphasize that fee petitions also occur when there is back benefits, but if there was more than one representative on the claim, one that got the boot or withdrew but didn't waive fee, then everyone's got to submit a fee petition that was involved, and the SSA divvies up however they see fit. But the important thing to know, which was after number 7, about amounts of benefits payable, the SSA definitely considers if there was back benefits, and also, are you a person that's going to have $1,000 a month of Social Security disability, or is it SSI? I think they're going to really keep that fee very trim, because they're not trying, it would defeat the whole purpose, right? They don't want, the attorneys take the hit and the non-attorney reps take the hit, but that's just the nature of the beast here. I think if there is back benefits, they'll probably look at how much back benefits there were. If there's no back benefits, they will certainly be looking at what is the person going to be taking home that they're going to now have this big bill. If it's a $4,000 monthly amount, they might be more apt to give a more reasonable fee from the standpoint of the work performed. But a lot of the time, the fee petition produces an award that doesn't come close to covering the work done. But that, again, is the nature of the beast. Again, we don't prefer fee petitions. I would imagine if the case took 5 years and multiple hearings, then you're going to probably be seeing more than 7,200. And we do have a lot of those that go in multiple hearings. But in my experience, not a lot of fee petitions. And I'm very grateful because they're a train wreck. You wait forever, SSA loses it. It's just a disaster. But it's a necessary evil because you still need to get paid on some of these cases. Okay, so that's just what I wanted to go over about the fee petitions. We do have additional videos on how representatives officially before the SSA, that represent you in official capacity before the SSA, not just, consultative attorneys or anything like that, but when they're actually hooked with your case, what that's about, what they do, what some do, what some don't. And also, I think there's a video on when you want to get rid of your representative, things you should think about before you actually do it, because you might change your mind. All right, I will talk to you guys later. See you soon.